Hi, my name is Harvey Koning and I'm here with Beth Skaggs. We are lawyers at the Varnum Law Firm and we are proud to be strategic sponsors of MGA, Manufacturing Growth Alliance. We are here today to talk about a hot legal topic, non-competes, and provide you with some useful information. So we're just going to go ahead and jump right in. I'm a business lawyer. Beth works in the employment and labor law area. And Beth, non-competes, are they enforceable in Michigan?
They are, yeah. Usually the courts, when looking to enforce a non-compete agreement, will want to make sure it's reasonable both as to how long it lasts, the time, what sorts of activities it covers and prohibits the employee from competing in, and is it reasonable in terms of its geographic scope. But if those three elements are met, it will be enforceable in Michigan.
Great, so if you do it right, it's enforceable. Let's talk about some of those components. Tell me a little bit about the time duration. How long can it go? 6 months, a year, 2 years? How long can you lock an employee up with a non-compete?
In most cases, 6 months or a year will be enforceable, and there are some times when even 2 years might be the enforceable length of time for a non-compete. When you get beyond 2 years, it starts to become much more iffy. So we usually recommend, if you want to make sure your agreement is going to be enforceable, you look at one of those shorter time periods, 2 years or less.
Okay, because if you push the limits, you're at risk it might get thrown out.
You are, yes.
Tell me a little bit about the scope. Can you just say no other manufacturing company in the United States? What is the scope of the non-compete?
The courts like to see that the non-compete agreement is narrowly tailored to exactly what your business is. So if you're in a particular type of manufacturing a particular type of product using a particular method, and you limit your non-compete agreement to cover that, it's much more likely to be enforceable than something that's much broader.
And that's because courts really don't want to limit people's ability to get a job and work, right? They're trying to balance that with the employer's need?
That's exactly right. They want people to be able to earn a living, be able to feed their families and pay their rent. And they're more likely to be able to do that if they can get a new job. So they want to make sure that your non-compete is narrowly tailored to just the specific industry that you're most concerned about.
Sure. And at a particular company, are non-competes for everyone, all employees, or should you pick and choose which employees should have non-competes?
We absolutely recommend that you pick and choose and focus in on those employees who would be able to do the most harm to your business if they were to go to work for a competitor. Those are most likely to be your sales staff, people who have unique personal relationships with your customers, or potentially your technical people, folks with very detailed knowledge about confidential and proprietary information of the company.
Right, so if you went to court and you had a non-compete with a back office person or a maintenance staff member, that's going to be a little more difficult to justify why you even have a non-compete with this person.
Absolutely, absolutely. Usually non-competes are going to be most effective if they're reserved for those higher earning individuals that, like I said, have the most ability to damage your business if they were to go to a competitor.
Yeah, let's switch gears a little bit and talk about other states. Some of our manufacturing clients are in multiple states or have sales going on in multiple states. Are all states like Michigan, are non-competes enforceable everywhere? How does that work?
It is completely dependent on the state. Many of you may have heard that non-competes are outright prohibited in some states. California comes to mind, but there are other states as well, such as North Dakota and Oklahoma prohibit non-compete agreements. So you're going to really need to focus on what state are we talking about, where is that particular employee actually working, and what state law is likely to apply to that employment relationship.
Good to know. And what about all these stories in the news about federal bans on non-competes? What's going on with that?
Well, there actually has been a proposal by the Federal Trade Commission to ban non-competes in the United States nationwide. That has not become formalized yet. We expect if the FTC does actually follow through and enact that ban, there will be legal challenges to it, so stay tuned. We're not sure what's going to happen there. But yeah, there's a lot of movement to ban non-competes at the federal level.
Oh, interesting. And that's an agency action, like they just kind of did it by
Yep.
fiat? It's not a law that Congress passed?
Well, they have to follow certain rules for implementing new regulations, and that's probably where the legal challenges are going to come up. Did they follow the rules correctly if they do decide to roll out a new regulation that bans non-compete agreements? But yes, that is something that potentially the FTC could do. It will just depend on if the court thinks they have the legal authority to do it.
Great. Let's go and imagine you're at a particular company and that company is interested in rolling out non-competes to its key salespeople, key leadership, key technical people. How does one do that? Do you have to pay the people who are getting the non-compete? How do you roll those out?
Well, again, this is very state specific, but in Michigan, no, you don't need to pay somebody something additional to get them to sign a non-compete agreement. You can just hand them the non-compete agreement and let them know that their continued employment with the company is dependent on them signing the agreement. So you can require them to sign the agreement in order to keep working for your organization. That is a legal way of entering into a non-compete in Michigan. It does differ by state, so again, make sure you know what state you're dealing with before you decide to go this route.
It's fair to say, though, that that's probably not a very fun conversation. Here's your non-compete, sign it or else. Is it sometimes done in connection with a promotion or a bonus or a new comp plan, or
Yep.
what can you tell us about that?
Because the difficulty of those conversations, you're exactly right, Harvey. It is often done in connection with giving someone a promotion to a new position or perhaps new responsibility or a pay raise or something like that. The best, most effective way to do it is obviously to do it at the time you hire the individual, right? When you're bringing them on board as a new employee, that's when you ask them to sign the non-compete.
Standard procedure. Great to have you here.
Yep.
Here's your offer letter. Here's our standard non-compete. Off we go.
That's right.
Great. So say we successfully implement this. We have some non-competes in place with a key individual. Somebody leaves and starts competing. What do we do? How easy are they to enforce? What does one do?
Well, there's many different ways you can take. One of the most common things we do is we recommend you consult with legal counsel. Legal counsel may start out by sending a cease and desist letter to the individual, telling them that they are in violation of their agreement and they have to cease doing what they're doing. Sometimes legal counsel may recommend that you actually send a copy of that letter to the new employer who's now hired your ex-employee. So that new business knows and is on notice that that employee may be acting in violation of a non-compete. If that cease and desist letter doesn't work, the next step is to take them to court. And that's often in the form of seeking some sort of temporary restraining order or even a preliminary injunction prohibiting the employee from doing whatever it is the employee is doing that violates that non-compete.
So once you get to court, if you get to that point, is it a slam dunk or does it depend on the judge, the contract, the situation? What do you find in practice?
It very much depends on the judge, the contract, and the situation. That's absolutely true. And often what will happen, again, because judges don't want to prevent people from being able to earn a living, often what will happen is the judge will really encourage the parties to try to work out some sort of arrangement. So, perhaps they'll work out a deal where not all aspects of the non-compete agreement will be fully enforced, but the employee will agree, okay, I'm not going to solicit these 10 clients, for the next 2 years. Whatever the case may be. Try to work out some middle road that addresses the company's needs in protecting their confidential and proprietary information and their unique personal relationships with clients, but also, again, giving that employee the ability to earn a living.
Interesting, and that's a good transition to the next question. What if it's the other way around? Somebody comes to us to be a new employee and they have a non-compete from somewhere else. Is that a showstopper? Do we have to stop? What do we do with the employee that comes to us with a non-compete?
Well, again, it's going to be very dependent on the circumstances, but that's certainly a question you want to be asking anybody that you're hiring is, are you bound by any sort of what they're called restrictive covenant agreements that may in any way limit your ability to work for us? You want to know that up front. And then you're just going to want to take a look at what the agreement says and whether it may prevent that individual from working for your organization. You're going to want to make sure you flesh that out beforehand.
Good to know. Now, we've been using non-compete as a shorthand here. When you see a non-compete agreement, what are the basic components of that in a typical non-compete agreement?
There's usually three major components. Number one, there's what the actual non-compete component, a non-competition clause, which prevents the employee from working for a competitor, however you may define that. There's also often a non-solicitation clause, which prohibits the employee from soliciting certain clients, maybe all of your clients, maybe some of your prospective clients. That non-solicitation clause may also contain a provision that prohibits the employee from soliciting other employees to leave that business and go to work elsewhere. Many people are familiar with that. And then finally, there's the biggest one, the one that we most commonly see, which is a non-disclosure provision, an NDA, or often called a confidentiality provision, that requires the individual to keep confidential that's confidential and proprietary information of the company.
Great. And is it possible to do a variation on that where maybe it isn't a full non-compete, but it's just a non-solicit? It says you can go work for somebody else, you just cannot solicit the customers you had contact with while you were here.
Yes, that is very common and even more likely to be enforced because, again, it's not restricting the employee's ability to earn a living, it's just limiting who they can have contact with for a period of time after they leave your employment. So, yes, it's very common to see agreements that are limited to just the non-solicitation piece and or the non-disclosure piece.
Okay. And now I got to ask, can you just grab a non-compete form off the internet and roll it out at your company, or what's the best way to set yourself up for maximum success?
Well, given all the intricacies of state law, as we've already discussed, and also given how delicate judges are in enforcing these sorts of things, we definitely recommend that if you take one off the shelf, make sure you run it by legal counsel before you roll it out to your employees. You may just want to start with legal counsel because they're going to make sure you get it right the first time.
Right, so ounce of prevention beats the pound of cure trying to enforce a
That's
bad
right.
non-compete on the other end.
Yep, absolutely.
Excellent. Any other words of wisdom for a manufacturing company out in Michigan that's thinking about non-competes and perhaps using them in their business?
Just tread cautiously and make sure you've got full legal counsel before you start rolling them out.
Right. Is it fair to say that it's not an ironclad guarantee? They don't always hold up in court. Sometimes you end up working it out. It's more complicated than it may first appear.
Very true. Very true. Yes. Again, it's going to be very dependent on the situation, and the courts are going to scrutinize every aspect of them.
Great. And just one point of clarification, when we're talking about non-competes, we're talking about individuals that work at your organization, not non-competes when buying or selling a business, and certainly you never want to have a non-compete with a competitor because that's illegal. That's another video for another day. But that's all we have, and we are so glad to have this opportunity to share this information with you and wish you every success in your business. Thank you.
Thank you.